Good afternoon, esteemed colleagues, distinguished guests, and all our participants joining us today. We thank you for making time on this Friday. I'm thrilled to welcome you to our webinar, Navigating Cross-Border Data Flows in Africa, Legal Challenges and Opportunities. Today, we are joined by a panel of distinguished experts who will share their unique perspectives on the complexities of data protection legislation, cross-border data flow, and the impact of free trade agreements as well, and data privacy across our continent. Allow me to introduce the guests we have today. We have Ms. Halila Gbai. She is a research and policy assistant at Open African Innovation Research Network. That's Open Air. We have Dr. Sandra Makumbirofa, who is a senior researcher at Research ICT Africa with 10 years of experience in economic research and policy. At Research ICT Africa, she leads research on digital trade, economic policy for AI, and mobile data pricing. We have Dr. Melody Musoni, who is a policy officer at the European Center for Development Policy Management, ECDPM for short, focusing on digital economy and governance. We also have Ms. Catherine Muya, who serves as the data policy advisor to the African Union at GIZ, supporting the implementation of the African Union Data Policy Framework through the EU-funded Data Governance in Africa initiative. We are privileged to have them with us, and I look forward to their insights, which will undoubtedly enrich our discussions. So before we engage the panelists, I would like to give a brief presentation on the research we at CIPID did on cross-border data flows. Allow me to project the brief presentation that I have prepared. Just a minute, my computer is glitching. All right. All right. I hope you can see my presentation now. Okay. So cross-border data flows in Africa, exploring legal frameworks and regional importance. This was a report that we conducted in the late quarter of last year, basically looking into how African nations have gone about regulating cross-border data flows, and also seeing how free trade agreements and also economic partnerships impact the space. So allow me to begin. So what is data? Data in a general sense refers to information that is collected and stored for reference, analysis, or computation. It can be qualitative or quantitative and can take various forms: numbers, text, images, or sounds. And examples I can think of is health data, we have trademark data, we have patent data, we also have statistics, traffic statistics, and all that is data. So data can be personal data. This can be your name, your phone number, or sensitive personal data, which is more personal and needs to be more protected, which is genetic data. And examples, therefore, are genetic data, biometric data, and we also have non-personal data, which is environmental data and industrial data. So African countries' legislations. So the conversation that, or rather what African countries have chosen to legislate is more on the rules on the processing of personal data. This is not to say that this is comprehensive because, as stated before, there exist other forms of data. And all of this can be non-personal data, which may not fall under the ambit of data protection acts. We have business data, environmental data, infrastructure data, traffic and transportation data, etc. So what was the purpose of our report? The report was aimed to evaluate how cross-border data flows are regulated within Africa, focusing on the roles of domestic legal frameworks, free trade agreements, and economic partnerships. So an overview of the legal frameworks. So what our research has found is that most countries have chosen to adopt a conditional model. Of course, this is no surprise since most DPAs, or rather African DPAs, are modeled off the EU GDPR, which is human-centric. So therefore, countries are not abolishing trade of data, but rather what they're doing is that they're saying that there are certain conditions that must be fulfilled if we're going to transfer data outside of Kenya. For this, we have Kenya. The Data Protection Act mandates that personal data can only be transferred outside of Kenya if the receiving country provides adequate levels of protection. We have the same with South Africa, which also adequacy measures must be satisfied if personal data is supposed to be transferred. And this is also the same with Nigeria under their act, which requires any transfer of personal data outside of Nigeria must ensure adequate protection measures are in place in the recipient country. So key challenges. So one of the key challenges we noticed in our report is that African nations face significant challenges due to the discrepancies in regulatory frameworks. This fragmentation hinders the seamless flow of data across borders. So what do we mean by fragmentation? So each country tends to have its own approach to regulation. Some are cybersecurity centric, some are for national interests, some share data based off the promise of trade, or rather the benefits that we'll get from trading partners. And all this affects how countries develop national policies towards the sharing of data. So this lack of uniformity in how digital trade data and handling are regulated across borders results in very complicated compliances for businesses, especially those who are wanting to operate in multiple countries. We also have an issue where enforcement can differ significantly. So some nations may lack the resources or the institutional framework to enforce data protection laws effectively. And this also leads to gaps in compliance and security as well. So regional recommendations. Though we do not have a policy or a centralized policy or legislation that tells us how we can regulate cross-border data flows, we do have the AU Data Policy Framework of 2022, which recommends that African countries should work towards harmonizing data protection laws, development of digital infrastructure to support safe and efficient data flows, and align to global standards. So already you can see a kind of tug of war where countries would rather prioritize national interests over continental interests, which of course goes against the vision where we want Africa to become a digital single market. So FTAs and partnerships, how do these affect how countries develop policy or legislation towards cross-border data flows? So I think as we've all have heard, we are, as Africa, have agreed to establish the African Continental Free Trade Area. So, and with free trade means that there should be trade liberalization or liberalization of data. So again, the back and forth, do we pursue continental interests or should national interests come first? Then when it comes to economic partnerships, a key example is the economic partnership that's currently being negotiated between USA and Kenya. Though we do not have any final text of what this partnership will look like, we can take an educated guess based off the USA's current administration, which can be boiled down to America first. And that may also cause Kenya to share data against interests of protecting policy space for trade. In conclusion, there's a need to harmonize and implement policy, raise awareness, invest into infrastructure, which is very expensive, and tap into the full potential of digital trade and the continental vision of establishing a vibrant African market. This is in line with Agenda 2063 and the African Continental Free Trade Area. So just a parting shot is that as African nations, we are new. We are new to the data space and the regulating of data. But as we become more advanced and globalization takes its course, this space should become very more interesting as the years come by. Again, we are very young into this space, so we may not have all the infrastructure or all the talent that we need right now. But as we develop, surely we have more interesting things to come. So now I'll stop my presentation and jump straight into the discussion we have with our panelists. All right. The first question will be to Miss Haili Lagbae. And the first question is, what are some of the most significant barriers to implementing effective data governance systems in African countries?
Thank you so much for your question. Good day, everyone. What I would like to say is an honor to be here, and also thank everybody who made out time to join us today in our webinar. So in answering your question, I think it's important that before we go into data governance or cross-border data flow, it's essential we understand what we mean by data localization, because they both work hand in hand. So when we talk about data localization, we're talking about keeping data within a country. Governments and countries do this for several purposes, such as privacy, data security, national security, or even industrial policy. When we talk about cross-border data flows, we're talking about transferring data from one country to the other. And essentially, it doesn't necessarily mean that. It can be maybe if you have data in location A and you give somebody in location B access to such data. So we can say there is cross-border data transfer. So when we talk about data governance system, we mean principles that facilitate data sharing while also safeguarding the rights of data subjects. So the challenges and barrier affecting effective data governance system in Africa, I would say, is a combination of technology, financial, policy-related issues, and even cultural and infrastructural limitation. So the first one I would like to explain is limited institutional and regulatory capacity. In Africa, there's shortage of functional institution and expertise to effectively monitor how data governance policy is implemented. Many data protection authority, they lack the independence, they lack the resources, they lack the expertise, and even technical skill to ensure the implementation of the laws that we have. The government often struggle with underfunded regulatory bodies. This also results in weak monitoring and enforcement system. There's also a lack of specialized training program for policymakers, legal experts, and technology professionals in privacy, cybersecurity, digital trade regulation. So all of this hinders an effective data governance system in Africa. The second one I'd like to point out is infrastructural constraint. Like our moderator earlier stated when he was giving his presentation, in Africa, we have inadequate technology infrastructure, which is a major hurdle in effective data governance system. Even if theoretically we have laws in some African countries that deals with effective data localization and even data governance system, we don't have the practical means for implementation, because in Africa, essentially, we have no data centers, we have no secure cloud storage for data storage or even processing of this data. So many African countries will lack advanced digital infrastructure necessary to implement and for efficient data governance system. Among all of these, we also have issues such as low internet penetration, unreliable electricity, and limited cloud computing services, which altogether hinders data protection and enforcement. The third challenge I would like to talk about is resource and funding limitation. So like I had earlier mentioned, we have limited financial resource, and this financial shortfall, it affects the ability for us to invest in the technology we need and even training our data protection authorities on how to navigate this struggle and implement initiatives that promote efficient data governance system. We also have the issue of fragmented data localization laws. Like as our moderator earlier stated, in Africa, we have divergent laws that has to do with data localization and data protection. So while some countries like South Africa, Kenya, and Nigeria have robust and comprehensive data protection laws, there are some countries that doesn't even have any data protection laws. And even the ones that have, they lack implementation. So all of this creates problem in terms of implementing effective data governance system. So this lack of regional harmonization, it makes it difficult. It makes compliance difficult for businesses that are coming into our region to conduct transaction. It makes it complex for them. This altogether discourages foreign direct investment and limits African participation in the global economy. So the last one I would like to talk about is balancing innovation and protection. We all know that there is a very thin line when it comes to protecting data-driven innovation and ensuring adequate protection. And also, sorry, there's a very thin line when it comes to protecting data, like ensuring the privacy of citizens and also ensuring innovation, that is, promoting the industrial economy. So African, we have to find a way to balance this thin line. And in addressing this, we need a coordinated effort to develop continental level regulations that support both the free flow of data and the protection of African digital sovereignty. Thank you.
Thank you. Thank you for your answer. I'll now move on to Dr. Melody. And the question for Dr. Melody is, what role do private cloud service providers play in cross-border flow of data? And how should they be regulated?
Thank you, Calvin. Good afternoon, everyone. So when I was doing my PhD studies, my supervisor used to say, whenever you are explaining your thesis, try to speak as if you are talking to your grandmother. That way everyone would understand. So I'm with my interventions, I'm going to try to give as many examples that are more practical as possible. And especially when we are talking about cloud services. So when I was still in university, I used to walk around with my USB and an external hard drive. And the reason why I did that was because my laptop didn't have enough internal storage, and you never had enough. You're a student, you're constantly downloading movies, music, and things like that. But fast forward to 2025, I don't even have anything on my devices anymore. Yet I'm still streaming the movies that I like, shows that I like to watch. I'm still uploading content online. And why is that? It's all made possible because of cloud services and cloud computing. So when we are talking about cloud services, it's not something that is very distant from what we are doing every day. To be able to send an email to someone else, you are making use of cloud services. So if I were to define cloud services and cloud computing, it's simply that ability for you to use someone else's computer and computing resources without the need of you actually owning a device or even having to go through the burden of actually maintaining a device. And now, when we try to connect to this discussion on cross-border data flows, you actually realize that cloud services, they are actually the underlying infrastructure, the digital infrastructure that we actually need to be able to facilitate some of the data exchanges that are happening and to facilitate some of the cross-border data flows. So if we are talking about digital trade, for example, if we are talking about digital financial services and digital payments, all of that requires or rely on use of cloud services in one way or the other. So if I'm to give another example as well, maybe you are Nigerian or you are Zimbabwean and you are working in South Africa and you want to send remittances back home. Whether you are using Western Union, whether you are using World Remit, Remitly, Mukuru, it doesn't matter. All those services rely on cloud services in order to transact. So you actually see that cloud services generally, they play an integral role when we are thinking about cross-border data flows, and when we are talking about the African continental free trade area and the digital single market. And then when it comes to the regulation of cloud services, I think that is where the conversation becomes interesting. But there are 3 points that I need to set out first. So the first one is, I think the speaker who went before me also mentioned it. When it comes to the African cloud market, it's mainly dominated by just a handful of companies, and the majority of these companies, they are actually foreign-owned companies. And that raises questions from a competition law perspective, because you don't have local owned companies or entities that are actually in the space. And then because the majority of these companies are also foreign owned, some of them don't even have a legal presence across Africa. So you could be a government in, say, Burundi, and you are making use of cloud services and using maybe AWS, but you don't have AWS or Microsoft or Google actually registered as a legal entity in your country. So from a legal perspective, that also raises questions around issues of jurisdiction. How do courts actually exercise jurisdiction over these countries that do not even have any form of legal presence but offering services in your country? And then the third point I want to mention again is the majority of the data centers that serving the African market, they are actually located somewhere else. So remember I said cloud computing, it simply means you are using someone else's computer. So they still need to have servers somewhere. They still need to have data centers. So the majority of these companies do have data centers, but they are not really in Africa. So it's only a handful, again, of data centers that are in Africa. I think South Africa has a couple, Nigeria, Morocco, and I think Kenya also has a few data centers as well. But the majority of African countries do not have any data centers. So they are using cloud services, but their data is being hosted either in South Africa, Nigeria, or even in Europe. So that also raises some legal questions and concerns, especially when it comes to data jurisdiction. If you are looking, for example, at access to data jurisdiction or electronic evidence for criminal investigation, how do you go about it? This data is actually not hosted in your country, it's hosted elsewhere. How do you navigate the legal rules around that? And even for governments, there is that question again of, we have these big companies that are basically in control of our data, whether it's government data, whether it's citizens' data. They have massive amounts of data, yet we don't really have control over them. What does that mean for our sovereignty? So there are questions around digital sovereignty and what it actually means for African countries. And then, so those are the 3 points I wanted to raise. And then when it comes to a regulation of cloud service providers, what is actually happening is making that distinction again between personal data and non-personal data. So with personal data, we have data protection laws. I think the speaker who went before me also spoke a bit about data protection laws. And with the data protection laws, they also provide guidance on how you go about when it comes to sharing data, transferring data from one country to the other. And they also set up regulatory agencies to be in charge of enforcing compliance, which is what we actually need. And then from a non-personal data perspective, how cloud service providers are being regulated, it's also sector specific. So you see different sectors actually come with their own regulations or with their own guidelines to sort of regulate how cloud services are being used within that sector. I remember, I think when a lot of banks in South Africa around 2018, thereabout, started migrating into the cloud, the Reserve Bank of South Africa had to issue guidance or guidelines on how to make use of cloud service for purposes of banking. And the other 2 examples I can give as well, Ethiopia did the same. And in the case of Ethiopia, they do not allow ATM operators to send transaction data outside of Ethiopia. Similarly, Nigeria's banking sector, the central bank, also issued similar regulations around that. So if you are in Nigeria, you use a Nigerian bank account, you want to make payment to another person in Nigeria, what they now require you is everything, that transaction, it has to be done internally within the country, and you don't need to use foreign services, for example, like MasterCard or Visa. So those are some of the ways in which sectors are trying to regulate cloud services. That being said, linking to the conversation that the earlier speaker raised, the issue of data localization, what we've noticed is that some countries are now approaching this question of regulating cloud service providers by insisting on strict data localization measures, where you are not allowed, if you're a service provider, you are mandated to have data centers within that country, and in some instances you're not even allowed to share data. And I'm just going to mention two things because I see I'm running out of time. I think when having these discussions on data sovereignty, I think we've been making a lot of progress in trying to explain to policymakers that the focus should not be about where the data center is. It should be about whether you can still exercise sovereignty and control over this data. But now with Trump in power, and I don't know if you've been following the news, he recently announced that he's launching this huge project called Stargate, and they are investing up to 500 billion US dollars towards that project. And the purpose of that project is they want to build data centers in America. So for me, I was just looking at that Trump effect to say, what does this mean for a lot of African countries? So you see, I'm sure we'll still start seeing a lot of African governments now going back to insist on local data localization and insisting on data centers, which is something that in the case of our African landscape, we don't necessarily have the capabilities. And just to end off on the regulatory part, so apart from data protection law, sector specific regulations, we also need to rely on our contract law. At the end of the day, these are companies, you enter into contracts, whether it's government, whether it's private. And in terms of the contract law, the important provisions that we need to make sure is understanding location of data centers. Where is the data going to be located? The security safeguards in place to protect this data, issues around vendor management or management of third parties who have access to this data. So I think contract law, it still plays a big role. And within data protection laws as well, we have agreements like data sharing agreements, binding corporate rules that also try to help in understanding or navigating issues around compliance when it comes to cross-border data flows. So I'll end there. I apologize for exceeding my time.
No worries. Thank you so much for the insight. I'm pretty sure our guests are enjoying the little nuggets of knowledge. The next question will be for Dr. Sandra. And the question is, how can African countries align their diverse regulatory frameworks to facilitate smoother cross-border data flows without compromising national data protection standards?
Thank you, Calvin, and thank you for having me as part of this interesting conversation. So, how can African countries align their diverse regulatory frameworks? African countries have a responsibility to protect the personal data of their citizens, and at the same time, there is need to foster cross-border data flows to encourage trade and economic growth, especially within the AfCFTA. The key challenge lies in ensuring that data protection standards are upheld without creating barriers to the free flow of data between countries. I think if countries can shift the focus from national control to include regional harmonization and simplifying the regulatory framework, this would allow more flexibility in cross-border data flows and at the same time maintain robust data protection measures. In terms of sovereignty, I think Melody touched on this. Each country has sovereignty over how it handles data, including decisions on data localization, whether the data that they have from their country can be transferred outside the country. Some countries may implement strict data localization laws for sensitive data, which can conflict with the open cross-border data flows that are being encouraged in the AFCFTA protocol on digital trade. At the same time, localization can protect citizens' data, which can also hinder the free flow of data necessary for digital trade within Africa. I'd like to add on to the excellent findings that Calvin presented on to highlight some of the findings that we found from our paper that I collaborated with my colleagues, Jackie and Nawal. We found that at the national level, there are 36 out of the 54 African countries that have regulations on cross-border data flows. And these data protection regulations, they span over different time periods. The earliest legislation was enacted in 2001 from Cape Verde to the most recent one in 2024 from Ethiopia. And what we've seen in that trend is that the earlier versions of data protection laws from African countries are more sophisticated and comprehensive. And they generally, recent legislation more explicitly addresses cross-border data transfers, and countries are aligning their data protection laws with the regional and international frameworks, which is a move towards a good direction. What we've also found is that many African countries do not recognize other African countries' data protection laws as adequate, which creates problems for sharing data within the continent. For example, on Morocco's list of countries with good data protection included no African country at one point, and Tunisia's 2018 list only had 5 African countries, just showing the difficulties that countries are facing with cross-border data flows. At the continental level, the AU is working on developing standards for integrated data systems across member states. These technical standards aim to ensure that countries can connect their data systems in a way that allows for seamless data exchange within the continent, maintaining consistency and reliability across the continent. This involves classifying data in ways that makes it easier to manage and protect, ensuring that sensitive data is treated with the necessary levels of protection, and the less sensitive data can flow more freely across the different national borders. The harmonization of these technical standards and the adoption of unified data policy framework is a gradual process, and the idea of this is to reach a consensus among African nations on the fundamental principles of data protection and cross-border data flows. We also have the progressive AU data policy framework, which encourages countries to adopt data protection standards through their respective regional economic communities. These frameworks balance the free movement of data with fairness, with risk management and sovereignty, while establishing trust mechanisms for data sharing to ensure that there are mutual benefits in this data sharing. They also encourage data sharing amongst preferential access to African data for African developers, African researchers, so that we are able to use our data to make solutions for African problems. The AU data policy framework also supports the creation of a single digital market through clear principles, capacity building and monitoring, and it enables inclusive and clear guidelines of sustainable data governance across African countries. So implementation of the AU data policy framework principles is key to making sure that African countries align the different regulatory frameworks that they have within their countries, as well as making sure that they don't compromise on the national data protection standards. Yeah, thank you.
Thank you so much for that answer. The next question is going to be from Ms. Catherine Muya. And the question is, what are the advantages and disadvantages of African nations adopting a conditional cross-border transfer regime? Does less liberal flow of data mean more barriers to trade?
I think I saw this question, it was very interesting in terms of the quantification, right? Because I think the idea is that you build a trust environment when you have conditional data flows, that you know that the impositions that you put on the receiving country, for instance, are to create this level of, as you mentioned in your presentation, adequacy, or to satisfy some sort of requirement to make everybody feel comfortable and trusted to operate within this digital environment. And I think if you compare this to like more open, and what the risks would be that you would have like a less trusted system or a less trusted environment where even consumers are not really willing to participate, or they're not really willing to engage, right? And I think I want to answer this in this context where you rightly presented that we have different legislations. And I will give an example when it comes to inter-African trade, for example. And let's take a regional bank in Eastern Africa that's operating in Kenya, has their servers and everything located in Kenya, and is serving customers across the region. Of course, let's say by 2019, Kenya has an adequate framework. So the standard that they enforce is, I guess, quite high because you're able to lodge penalties and everything. But then it should then apply, like this group or this group business should then apply the same standard everywhere. So that should make it easy to trust this bank, to trust like the transactions, to trust that the same standard is applied. And that's good for businesses, right? So if and I think the argument is more around the benefits that you get when you're enforcing this sort of conditions across the region, right? That you are creating this environment of trust, that people know that this is someone I can trust. If the penalties are levied, you assume that they apply the same standard, or that they fix this, or you can actually have a level of some sort of competency. Now, the problem comes when, for instance, as happened, and this is actually like a real example, as happened, one country in Eastern Africa then decides to have a data protection law that mandates that puts on local processing requirements. So the need for local servers, all this, and then sets up a stricter regime. And suddenly this company that was operating with one set of infrastructure has to then set up and build different infrastructures for different things, domesticate the data of all this. You could argue in one sense that it maybe might create a few jobs, but then you have to count this against all the cost you spent in building this infrastructure, right? And the fact that as a company, for business efficiency, I would want to have, like, it also increases the level of compliance for me, because I'm being regulated in Kenya, I'm applying the same standard across the group, and now I have to like change the standard to build a service just to comply with something, not necessarily because I wasn't doing it before, but just because you want to see me do it. And that's exactly the reason. And I think the challenge is that we are raising the cost of compliance. Like for the consumer, like I think the question is, does it change the impact for the consumer, right? And I was trying to Google and to check if, like, even for the countries that put the strict localization requirement, like I think in Zambia, for example, and Botswana, maybe they recently changed that. But like where they put this with the intention of, as Melody said, to promote the development of local infrastructure, has this actually led to any development of local infrastructure? Because I would argue, with no ability to quantify, so it's rather my observation, that like I think Melody presented, that a lot of the cloud infrastructure, the data centers that are being built are mostly resident in Nigeria, Morocco, Kenya. I think we have a couple of data centers, and all these are countries that are more like conditional, right? Like they're not less strict, like they're less strict in terms of how they deal with data flows. And so even as you put this strict requirements on like local processing and everything, it doesn't necessarily relate to a compounding or correlative investment in the infrastructure, unless you are really forcing this big companies, and you look at it as this big regional bank has the resources
to actually comply, but like smaller entities would not have the resources to comply with this requirement, and they either would not do it, or and how would you also check, how would you also enforce that this is being done? Do you also have the capacity? So I think in a way, the conditional regimes are good because they build trust within the environment. And I think it's good also for trade that people are applying the same standard. The less restrictive stress is also that you don't feel comfortable, right? Like if they don't have this. And I think there needs to be a balance between how we are applying these conditions, right? So it can't necessarily be very extreme, such that it's not conditional anymore, but it's just strict, right? That you have like local local processing requirements, storage requirements, and all these things. So I guess this would be my short or long answer to this question.
Thank you. Thank you for that. And the nuances of more compliance equals more cost. I mean, it's unavoidable, isn't it? A question for Ms. Gvae. The second question, in your view, how well prepared do you think the African Continental Free Trade Agreement is to handle the complexities of digital trade, particularly with respect to data governance?
The African Continental Free Trade Agreement, in short, the AfCFTA, which came into force in 2019 but officially launched in 2021, aims to create a single continental market for goods and services, facilitate movement of data, free movement of capital and people, and also deepen regional integration across Africa. It seeks to increase trade between African nations by reducing tariffs and other barriers, thus promoting free flow of goods and services across border. In the context of data governance and cross-border data flows, the AfCFTA recognizes the importance of digital trade in supporting its broader objective. The free movement of data is essential for the business to operate smoothly across national borders, enhance trade logistics, and drive innovation. As stated in my research and also in my paper, in my view, I don't think the AfCFTA does sufficiently address the issue of data governance. I mean, given that the agreement intended to propel African digital economy forward, the lack of attention to data governance, I would say, is rather disappointing. The AfCFTA does not have a comprehensive data governance framework to regulate cross-border data flows, data localization policy, or even digital sovereignty. In the whole of the agreement, the only reference to data governance is found in Article 15C sub 2 of the Protocol on Trading Services, which suggests that member states should adopt measures consistent with national data protection laws if they do not unduly restrict cross-border data flows. So I mean, this article or this provision is very vague, and it doesn't give a detailed explanation on what countries are to do when it comes to transferring borders across countries. The agreement did touch on data privacy, stating that state parties are not obligated to disclose confidential information if doing so would hinder law enforcement, violate public interest, or even damage legitimate commercial interests of enterprises, whether public or private. The Protocol on Trade in Services also include provision that shield state parties from disclosing confidential information that could impair law enforcement or adversely affect the public or legitimate interests of enterprises. So in these three provisions I just stated, while it provides some sort of guidance on how to go about this, it is not a comprehensive framework on data governance when we compare them to other international trade agreements, like the Regional Comprehensive Economic Partnership, or even the United States-Mexico-Canada Agreement, or the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, which provides, this agreement provides like detailed framework and detailed way on how member states that are bound under the agreement should share data, to share data across several countries. So I would say compared to these other agreements, in my view, the AfCFTA is underdeveloped and it does not provide adequate safeguards for personal data. And this is important because we need a framework that can be like a guidance for other countries when it comes to protecting personal information and even enhancing trade across countries. Because if the aim of the agreement is to facilitate trade among African nations, cross-border data sharing is an essential part of how this is going to be, this is going to be seamless. So I would say, in my view, no, it doesn't lay the groundwork and it doesn't have a clear data governance structure at both the national and continental levels. And this is important to help countries and also international countries seeking to do business in Africa. This will help elevate concerns about potential data breaches in cross-border data transactions, and also provide a secure environment for businesses and customers that are involved in this trade.
Thank you so much for your insights. I would like to pose the next question to Dr. Melody. And the question is, in your view or from your research, may you tell us some of the discrepancies between national and continental perspectives on cross-border data flows?
Thank you, Calvin, for that question. I think I am going to actually share some of our findings from a project that we did as ECDPM. I worked with my colleagues Purva Kakare and Chloe Tiven. And the purpose of that project was also looking at cross-border data flows in Africa. And we were mainly interested in understanding the continental digital policies, their position on cross-border data flows, and what member states are actually doing to align their national laws with the continental vision to share data. And what we did on that project actually was we first started with looking at the continental policies that we have from some of the frameworks that my co-panelists are talking about: the Malabo Convention, the AU Data Policy Framework, Digital ID Framework, the AFCFTA Digital Trade Protocol, the draft version, among others. And we looked at their position on cross-border data flows. And then we had to look at what is happening at national level. And we looked at 3 country case studies: Senegal, Mozambique, and Nigeria. And I think maybe I'll share that report, the link to that report in the chat box as well, because I think it's quite enlightening, because it not only gives you a legal perspective of some of these issues, but you also get to look at some of the challenges from a political economy lens and trying to understand how things are actually done in practice. So looking from policy to practice, how things are actually done. And I think I'm just going to mention 3 discrepancies that we discussed in our paper. So of course, after analyzing the digital policies that we have that have been developed by the African Union, we actually found that in general, yes, these policies promote to some extent the free flow of data and the protection of personal data. However, when it comes to member states and their efforts towards legal interoperability and policy interoperability, we found that it's very limited, and member states do not always strive to align with the continental commitments. And this is because of different reasons. And through interviews and engagements with people in different stakeholders in these countries, what we actually found out was that they tend to be more priority towards national interests. So national interests tend to trump the continental commitments. And also there are interests politically, maybe political interests, political tensions between countries, where some were even arguing that we don't trust sharing data with country so and so because we do not have a good political relationship with that country. Economic interests as well, and then generally social economic context also determine the extent to which African countries are interested in promoting free flow of data. So at the end, what we found was that regional integration and alignment with continental vision always came in secondary. And if I'm to give an example with the AU Data Policy Framework, it articulated actually how African countries are to go about in creating value out of data. It emphasizes on the need to promote the cross-border flow of data and sharing of data. However, member states are still insisting on data localization, as we have already alluded to earlier. And then another example, I think Sandra actually touched on that when it comes to issue of whitelisting. So for those who don't know about this term, it simply means a list of countries that a list of countries where a country can share data without having any barriers from a data protection perspective. And what we also found was that what actually informs the development of these whitelists is mainly economic interests and political ties. So there's less to do with protection of personal data, even though these whitelists are usually created under the guise of the need to protect personal data. And maybe I can just give another example different from what Sandra had already shared. If you look at Botswana, for example, I think it was 2021 or 2022 when it came up with its whitelist. There were EU countries on the list, and in Africa, they only had 2 African countries, South Africa and Kenya. And of course, it makes sense for South Africa to be on the list because they have economic ties with Botswana. But then we were wondering at that time when the issue was the whitelist was published, why certain countries like Angola and Mauritius were not on the list, because at that time they already had data protection laws. They already had data protection authorities and agencies in place who were actually enforcing the law. So that's where you again see that it's usually economic interests and political ties that is leading to informing the creation of these lists. And again, giving the example of the United States, I think most countries that have these white lists, the US is on the list, but from a data protection law, the US is not considered as a good country that protects personal data. So again, because of it being a major trading partner with a lot of African countries, that will also come into play. So apart from the economic ties and political interests, we also found that there are also historical ties and, of course, colonial legacy systems. So countries like Mozambique, for example, their approach to data sharing, especially in the banking sector, it's shaped by or they kind of follow the Portuguese systems, and the same with Senegal, because they were once a French colony. Some of their systems are still a reflection of those systems. And then the second point that I also want to discuss, and one of the issues that we found out, is the lack of enforcement. I'm sure lawyers in the room, they'll agree with me that for a law to be effective, you definitely need to have mechanisms in place to enforce compliance. But the problem that we have with many African Union policies and frameworks is that they lack the enforcement mechanism. There is no way to enforce these laws. So if we look at the Malabo Convention, if a country has ratified the Malabo Convention and even went a step further to develop its own national data protection laws, if it were not to comply with the Malabo Convention, what are the legal consequences for that? And in our research, we reached out to different lawyers, and some of them, we spoke to lawyers who actually litigate in the ECOWAS court. And it's a point they were raising, that most countries, they don't even respect court orders. And there are usually very few serious legal consequences that come from as a result of non-compliance with the law. So I think lawyers in the room, academics and lawmakers and policymakers, what we need to do is we need to start thinking about what is the most stringent frameworks we need to have in place to enforce compliance. And one thing that I've actually proposed in the past was we need to be more innovative in some of these enforcement mechanisms. And one thing that comes to mind is, if a country is applying for a loan, for example, or for funding, can't development banks and international partners make it a prerequisite for such a country to be complying with data protection laws and to be complying with the requirements of the Malabo Convention before they can provide any funding? And the reason why I'm saying that is we have actually seen that happen. I won't mention the names of the countries, but at some point, Some countries wanted to receive funding from the European Union, and the condition was you don't have data protection laws in place, and it didn't take long for those countries to actually come up with a data protection framework. So I know it's something that can actually work, but we just need to think if a more innovative way to do it. And the last point I also want to mention, which is also a finding from our report, was the issue of data deficiencies. We are talking about cross-border data flows, but we need to take maybe a couple of steps back. Do we even have this data? When we're talking about data, we are talking about information in digital form, in digital format. And looking at the state of digital transformation in most African countries, we are not even there yet. So a lot of African countries, they still experience these data deficiencies because they are still using pen and paper. They are still using those manual processes. And as a result, we have very limited information in digital format that we actually need to facilitate for the digital data economy. And also a lot of governments, they are still operating very outdated and incomplete data, which makes the data that they produce very unreliable and of less interest for purposes of innovation. For example, I was actually surprised in 2023, we did a project on digital ID systems in Africa. And I was surprised to actually learn that a lot of African countries didn't have national civic registration and foundational ID systems. And here we were coming and talking about digital ID, something that is a bit more advanced. So if we don't get our data infrastructure right and start generating this data, there is no data to speak of when it comes to cross-border data flows. And I believe that all these discussions that we'll be having, they become alien to the policymakers because they can't relate to anything that we'll be talking about. So I will share the report with everyone else, but I'll stop here.
Thank you so much for your answer. Yes, indeed, we need to start taking care of our own data, or taking it more importantly, or taking it more seriously and developing into it. Then we can have meaningful discussions on cross-border data flows. Because why would we share anything that we don't have? The second question, or rather the next question, would be to Dr. Sandra. And the question is, how might the proposed digital tax policies under the African Continental Free Trade Agreement affect cross-border data flows, particularly concerning data-driven services like cloud computing and e-commerce?
Thank you, Calvin. So tax, as you know, plays a very important role in African government revenue collection, and as trade barriers are being reduced under the AfCFTA, navigating the complexities of tax and cross-border transactions becomes very important. African countries currently have different tax rates, thresholds, exemptions, and administrative practices. As such that, with the increase in digital trade across African borders, there can be inconsistent or unclear tax rules for digital services, which may lead to several challenges. For example, compliance burdens, where businesses that offer digital services like cloud computing and e-commerce may face different tax compliance requirements from different countries. Each country could adopt different VAT rates or exemptions, as such that there is increased operational costs on businesses and administrative burdens. This would potentially deter businesses across African countries, and especially SMMEs, from expanding or fully capitalizing on the African market. The application of digital taxes could also impact the free flow of data across borders. Each member state implementing different tax policies, like I said, businesses will face regulatory fragmentation, leading to delays or restrictions on cross-border data flows. This could particularly affect cloud computing services, which rely heavily on the smooth and unhindered transfer of data across countries for storage, for processing, and delivery of their services. And we also have multinational digital companies that have a complicated relationship with African countries because of the lack of local presence in African countries and therefore a lack of tax revenue generation from the activity in African countries. These companies operate in African markets, but they avoid paying taxes locally by structuring their operations to minimize tax liabilities. In order to mitigate this, the UN has proposed international tax system of 15% corporate tax for these multinational companies. Though this is progressive, many African countries don't see this as a reasonable rate because they aren't receiving any tax revenue from these companies currently due to their lack of presence in their domestic countries. So to address these challenges, we would encourage member states in Africa to work towards harmonizing digital tax policies and establishing clear rules for taxing digital services. If tax policies are not aligned, then cross-border digital transactions could be subject to disputes between businesses and tax authority, potentially stalling trade. And we're also losing out on a lot of revenue our governments could be collecting from the big tech companies that are present in African countries and conducting most of the digital transactions anyway. The adoption of consistent rules would help with clarify with which countries VAT applies in each instance, for example, thereby reducing compliance, uncertainty, and making it easier for businesses to operate across borders. Overall, I think if member states establish clear and consistent tax rules that are harmonized for digital services, it would really help to create a more predictable and attractive environment for businesses offering cloud computing, e-commerce, and different digital services. This would facilitate and easier cross-border data flows and promote digital trade within our borders and unlock that greater economic opportunity that we are really hoping to find under the AFCFTA. Yeah.
Thank you so
Thanks.
much, Dr. Sandra, for your answer. The next question is for Ms. Catherine Muir. And the question is, what advice would you give to African countries looking to enhance their data governance frameworks to better participate in the global digital economy?
I'm tempted to say the exact opposite of everything Melody said, but I would explain. So I think you also pointed out, and I think she also pointed out the inconsistencies that we have when we come into the development of national data strategies, data policies, legal frameworks. And I think a lot of this is also because each country adopts a very different standard from their neighbor, from the region, from everything. In as much as they accept and they endorse these positions at the continental and regional level, they don't necessarily translate that into national policy frameworks. And so I think the point to start, as we rightly pointed out, on a continental level, I think that the frameworks that we have do promote cross-border flows. They ask for trust, security, cybersecurity, all these things. But at the national level, for various reasons that she already pointed out, and I wouldn't repeat, it's really difficult to marry a lot of this, what was actually accepted and what is actually endorsed at the last end. And so I think having this coming first and not coming last would also be an important, I think, would be one of the key ways in which we get to change this and achieve some level of harmonization. Because you rightly pointed out, there are different frameworks, there are different positions. There's no harmonized approach to what we have. And I think at the national level, it's particularly important because it's the last end and where you get a lot of country resources actually investing in this. So I think to begin with, what we are doing, for example, is we've supported the ECOWAS to revise their data protection. No, I get it wrong. I had the correct name. So, but it is basically the ECOWAS data protection framework, and I will get the right name and I will type it. This is not the right name. But the idea is that if this is aligned, then you don't need, and I think the second thing is that we need to have more Africanized solutions that are really tailored to what our problems are. We have a problem in trust deficit. How do we overcome that? I think that the reliance on regional frameworks, for example, if we adopt this at EAC, if we adopt it at ECOWAS, on SADC level, then that also takes us a step further into having some sort of uniformity, harmonization, not uniformity, but just like harmonization, right? And goes into building this trust, because it's easier then to have an enforcement mechanism when we are all like appreciating what we have. And so, for instance, now within the EAC, they come up with a data governance strategy, and I think would be looking at the data governance framework across the region. And I think it is important that the commitments that are actually agreed to at this level are then translated individually into member states with the same positions. So I think this is particularly important. And in our project with the domestication of the African Union data policy framework, we do try to support member states in the development of data strategies that are also aligned to the data policy framework. This basically means that look at the same principles and things like this and see if they can be translated, transposed in any way, adopted by the member state as they would like at national level, to sort of have some sort of harmonization. So that's the first thing. And the second thing I would also advise is, I think, more balanced approach to innovation, looking at how you can, like in this framework, provide incentivize rather than how do I put this? So, for instance, with like there is a need to develop infrastructure within the continent. It's extreme investment that comes into building of infrastructure, and it all goes down from my positioning from the policies that we have and incentivization of private sector. And it does not really mean like the big multinationals, but it also could be like looking at the private sector that we do have operating within our environment and how further can we incentivize them to actually develop this thing. So for instance, for data infrastructure, you would need cable, you would need all these things. And for example, promoting policies that have things to do with co-location, infrastructure sharing would depend how much connectivity we can cover as a continent, just to incentivize the existing telcos that operate to then be able to actually provide connectivity to underserved and underserved areas, and exploring partnerships that actually make sure that we are incentivizing the private sector and everybody else to actually invest in these areas. And so it's more not to mandate, but to look at how do we come up with policies that actually support some of those things that we say. If we say that we are committed to having mobile fast connectivity, what is our taxation system looking like? So, and I guess this is from a governance perspective, but even like a whole of government approach, who is checking within the government how we are doing this? Are we coming up with standards? And as was mentioned before, if we come up with a standardization and categorization framework at the continental level or at the regional level, like they are discussing on various regional blocks, then how do we make sure that our systems and our standards of interoperability then do actually like are able to integrate or basically are interoperable also at a continental level. If we don't adopt, or we are not really particularly quite serious around these things, right? And I think we also need to allocate resources, which is really difficult, especially because at national level, every state grapples with different things, right? Like the resource allocation for this activity might be less because maybe, let's say, there's like experience of drought or whatever, and so different member states are able to not allocate the same amount of resources. And so I think it then needs to be tailored into what are the existing institutions, how can the mandate be better strengthened to do this, because I think like domestication is not a one size fit all for all member states. The realities are different, the capacities are different, and the political economic situations are different. And I think it then takes this member state to see, like, how do we then do this, strengthening our own capacities, strengthening our own institutions, or creating new ones where it is actually a bit more rational, to create them. And I think the issue is, so I think the idea of just transposing what is like existing without looking into the tailor fit realities of different member states is perhaps not going to work. And so I would also suggest and advise that it's very tailor made. And yeah, I think a trusted framework, a secure framework, and in terms of security and cybersecurity, how we invest in that, and also how we leverage on regional support. So, for instance, in the SADC region, there is an existing already SADC SAT that is able to provide, let's say, cybersecurity assistance for member states in the region as well. So, how do we also leverage on this existing mechanisms, just to make sure that we are also able to benefit from the institutions that we create?
Thank you. Thank you for your answer. Wow, I am learning a lot with the panelists here today. I would like to move on to our Q&A session where we invite guests in the audience or attendees to pose questions to our panelists. There are a few I have here. I think one has already been answered, but maybe for the sake, so everybody's involved, I'd like to pose this question and whomever can answer this. And the first question is, which African countries have digitalized trade and finance related documentation? Example, letters of credit, bills of lading. The question also has a second part where he asks, do all African countries accept digital signatures? So whoever would like to take it up may do so.
Okay, I guess I could attempt. I'm not exactly a trade advisor, but I would say that from my experience, there are some countries that have adopted e-signatures, if this is what this question refers to. And I think there is also a provision on e-signatures within the digital trade protocol, sort of to encourage the adoption of this when it comes to actual trade. I'm not exactly sure as to the specific number of countries that have adopted this, but I can say that there are some with existing frameworks to adopt this. I think Kenya is one of them. I think this is as much as I can say on the question with regards to the bill of lading. I'm not exactly sure if I can, address that. I don't want to lie, to be honest.
Thank you. Thank you for your attempt. There's a question that was answered in the chat, but I'm just gonna reiterate it so that everybody's involved in the conversation. Does the Digital Trade Protocol compensate for the African Continental Free Trade Agreement on cross-border data flows? So does the Digital Trade Protocol address some of the inefficiencies or lacunas left by the African Continental Free Trade Agreement?
I think, Calvin, you have to start picking on us. I see Sandra has unmuted.
Yes, I was going to say, so what we found when we're looking at the protocol on digital trade is that it does address different types of data and how it will be handled. But what we found is that there are policy and legal incoherences between this protocol, what it says, and what other policies before it have said, like the AU Data Policy Framework and the Malabo Convention. So, for example, there's an article on cross-border data flows, and it says that African countries will open up their data for flows within Africa. However, if African countries find that there's a legitimate reason why they don't want to share their data, then they can still remain have their right to restrict that data flow. And what we found with that particular with that particular article is that it contradicts what the African Union is trying to do in allowing preferential access to African researchers, African data. So if a country is able to say that, I mean, it could find, it's not really prescriptive in terms of saying what kind of legitimate reasons can a country say we won't transfer their data, as such that it leaves some ambiguity there, which can just increase the regulatory burden and administrative burden for SMMEs or local researchers or developers who want to use the data. And we found that some of the articles refer to agreements that are going to be finalized in the annexes. The annexes are not yet published, but I mean, it's something that we're also just waiting for to see what the different member states agree on these annexes, which are supposed to be more prescriptive in terms of the kind of rules that will be implemented for the different cases that they may be. So yeah, that's just one of them. Thanks.
Sorry. Thank you. Thank you for your response. I'm not seeing any questions, any new questions. Perhaps I can ask my own. This would be to Dr. Melody. And the questions, okay, it's a two-part question. The first part would be, is the free flow of data detrimental to Africa? And second, how can we draw a balance between economic benefits to Africa vis-a-vis limiting the exploitation by foreign countries?
Thank you, Calvin, for the question. Unfortunately, I couldn't provide answers because I'm not a digital trade expert. So I'm happy that Sandra and Catherine had to chip in. So personally, I don't think that free flow of data is detrimental to Africa. On the contrary, I think that free flow of data actually promotes regional integration, and it is one way for us to achieve the fulfillment of Agenda 2063 and also meeting some of the ambitions that are set out in the AFCFTA. I think that if Africa is to move as a region and if we are to promote that digital integration, then people need to move freely on the continent using their digital ID to travel, to access public services, for example, and to make digital payments. And as far as the digital single market is concerned, we want data to freely flow. We want people and businesses to transact and businesses to transact and for purposes of trade. So at the end of the day, there is more value that comes with actually data flowing and freely flowing in Africa. Maybe what I can emphasize there is the need for more stronger guardrails to actually safeguard data, especially personal data. So having the data protection laws that we have and making sure that they are more robust, and the same with some of the consumer protection laws that we have, because we are now talking about cross-border transactions and interactions. It makes sense to have more stronger protections of the consumers. And I think we also need to find ways of strengthening and capacitating our data protection authorities. I think one of the speakers actually talked about this. The need to have to capacitate the data protection authorities so they can support us with compliance and enforcement. And I think on the issue of exploitation of African people and exploitation of our data, I think it remains as one of the concerns that our governments have, which is also one of the reasons that governments insist on data localization. And if you actually look closely, a lot of this exploitation is being done by foreign companies. And what I think we need to do for example, from a data protection perspective, is we need to work together. So instead of the information regulator of South Africa single-handedly taking Meta to court because of non-compliance or because of the Cambridge Analytica saga, for example, or the Kenyan Data Protection Commissioner going head on against WorldCoin for unlawful processing of biometric data. Why can't we actually have a legal vehicle or a legal entity that actually represents all the data protection authorities that we have? At the moment, we do have that network. I think it's called NADPA, which stands for should be the Network of African Data Protection Association Authorities, and it's more of a voluntary association. But I think what we need to think of is perhaps maybe a legal entity that is established in terms of the law, which has jurisdiction across Africa, and which is actually able to take some of the cases at a continental level. And I think, especially now with all the conversation around AI sovereignty and the development of AI in Africa, I think it's also important for us to have more competent regulators who will be able to actually help us in identifying some of the exploitation of data, the unethical practices on how our data is being collected and processed, and all kinds of data misuses. And we then need, again, to make sure that these regulators are actually capacitated to ensure that they are able to carry out their functions and mandate. So at the end of the day, yes, there are economic benefits that come with sharing of data, but we just need to have in place adequate safeguards to make sure that our data is being protected and to prevent any unethical practices which result in exploitation of our data, and finding ways to actually hold some of these foreign companies operating in Africa to hold them accountable. So I will stop there. Thank you.
Sorry, I was muted that whole time. Thank you so much, Dr. Melody, for your answer. I would like to pose one final question before we close for the evening, and this is to Catherine Muya. Are there any specific models or practices being adopted within the EU that we can copy and paste and apply here in Africa?
Okay, I'm going to be very diplomatic into how I answer this, because I also work for a project that is funded by the European Union. And the idea is not that we promote EU policy positions, even though this might look like what we do. But rather, the idea is that we support like we are centered on human-centered digitalization. And again, as I mentioned before, our idea is to promote the African Union Data Policy Framework as a policy legislation that's adopted by African member states and thus at the African Union to actually guide the harmonization of policies across Africa. So I know that there are many countries or some countries that then also have adopted this adequate provisions, for example, when it comes to GDPR, mostly because, as you rightly pointed out at the beginning, the legislation for regulations of personal data are modeled under the GDPR. And this is also why what exists as a supranational body within the EU is absent here, right? Because this is like, we don't have this supranational mechanism for regulation of personal data, for example. And so I would promote, or I would encourage that we promote African positions. So for instance, one thing I saw that was really good out of Kenya was giving like considering adequate level of protection countries that have ratified the Malabo Convention. And I think these are some things that we can encourage. But for us, like, or rather within the project, in ZADC, for example, I know there, I'm sorry, in EAC, for example, I know there have been discussions around what is the best model to adopt in terms of promoting cross-border flows, even in terms of legal harmonization. So I will give an example. Kenya, for instance, has relies on adequacy and has provision for binding corporate rules, which are absent in Uganda, right? and to have, so there's like what is present in one country is absent in another country, but they're all sort of borrowed from this GDPR concept, but without some sort of uniformity. So then we look to the EAC to then provide this uniformity, to provide the framework, and they can choose to borrow this model or system of binding corporate rules and include that in there. And you can look at different models and different policy positions. So what we did in our project, for example, is we did a study actually that was supported by Strathmore around cross-border data flows in Eastern Africa, looking at these different policy positions, looking at different regional frameworks, so not only the EU, but also other Asianic models that you could consider, and then proposing what would be suitable for African member states to consider. And it's still a decision of states and negotiating states to come to a decision, for example, on these matters, but they can rely on different models. So I don't want to propose any, but I do want to say that there are some that exist, and they can serve as a reference point. But again, we have to be alive to the fact that we don't have the same infrastructure in terms of organization, right? Like we have no supranational body, we don't have this sort of domestication, we don't have a unified framework. So we would then be discussing them. And yes, I can post the link to this study on the chat. I think it is called cross-border data flows something, but I can post it. And it's more around looking at the specific provisions and how they would make sense for the EAC, right? Because like binding corporate rules, where one country does not recognize them, another one recognizes them, it's a bit of a comme ci comme ça, right? So it's then, does the EAC want to come up with something that we can all use, even if it's adopted at EAC level or it's accepted at EAC level and covers up for what you have at national level? So I guess in this way, what I'm saying is a lot of things exist, but I would advise that they're domesticated with African realities.
Thank you. Thank you so much for your answer. It's now 4 minutes till we end the webinar. I would like to invite any panelist that has any parting remarks, any comments for us, the attendees. Please feel free. All right. Well, I guess mine is to say thank you so much, dear panelists, for agreeing, for making time on a Friday evening. For us, it's in it's East Africa time, so yeah, it's evening. We are about to close for the weekend. We thank you attendees for making time to attend, and thank you so much for being part of this webinar and this discussion. We hope we may have these in future, and we hope for more engagements with you guys moving in. Thank you so much for attending. We do appreciate it here at CBIT.
Thank you for having us. Have a good evening.
Have a
Thank
good
you
evening
for
as well.
having us.
Thank you for having
Enjoy your
us. Thank
weekend.
you to other co-panelists.